To rent a dwelling, you must reach an agreement with the property owner. The residential lease allows you to formalize this agreement in writing. A residential lease is a contract which must be respected. Normally, two persons are involved in this contract. First of all, the lessee. He is the one who will live in the dwelling. When you rent your dwelling, you will become a tenant. Then there is the lessor. He is the one offering to rent the dwelling. We'll also call him the landlord. The landlord has the right to set the rules on the use of the dwelling, but these rules cannot be discriminatory. A landlord cannot refuse to rent out his dwelling to a person because they are indigenous or have young children. He must also respect the regulations set out in the Civil Code of Quebec when applicable. True or false? The landlord can refuse to allow you to have a domestic pet in your apartment. True. The landlord can refuse to allow domestic pets in the dwelling if this prohibition is mentioned in the lease or accompanying regulations. As a contract, the lease has binding power, or we say is legally binding. The tenant and the landlord are required by law to respect what is written in it, as well as all of the regulations contained in the Civil Code of Quebec when they apply. It is therefore very important to carefully read all of the clauses of the lease before signing it. The tenant has the right to live in the dwelling in exchange for a rent payment made at a predetermined date as set out in the lease. He has the right to quiet enjoyment of the premises, but he has the obligation to respect that of his neighbors. The landlord is responsible for carrying out all necessary repairs, but the tenant is responsible for the everyday upkeep. The landlord is required to provide a dwelling in good condition and fit for habitation, but the tenant must return it in the same state. True or false? The landlord can request a deposit upon signature of the lease. False. The landlord does not have the right to request either a deposit or post-dated checks. True or false? A tenant can terminate his lease at any time. False. The duration of the lease must be observed. One can always attempt to negotiate an earlier termination with the landlord. According to the Civil Code of Quebec, a 12-month lease is automatically renewed unless the tenant has given notice of his intention to vacate in the 3 to 6 months before the end of the lease. A tenant can transfer his lease or sublet his dwelling to the person of his choice. The landlord cannot refuse unless he has a reasonable motive. The rules concerning a residential lease in a community are not all the same as those applying to a city dwelling. Why? Because the Indian Act provides that the occupation of community lands must in priority be reserved for members of that community. In general, a dwelling in a community will be reserved for members of the community. Nevertheless, certain regulations in the Civil Code of Quebec may apply. Before renting a dwelling in a community, it is important to become familiar with the policies and regulations that the Bank Council has adopted. A residential lease agreement with a learning establishment, such as a CEGEP or a university, is subject to certain regulations specific to this type of dwelling. Among other things, student residences are reserved for students, and if a person loses their student status or changes educational institutions, he must leave the residence. A student lease cannot be transferred to another person. It is the educational institution which chooses the person who will occupy the vacated room.